Okay, let's take a look at the first of our videos on liability and negligence, and we're going to focus on duty of care. And just in case you think I've gone completely barking mad because I've got a picture of a snail in the middle of the video, all, for those of you that don't know anything about tort at the moment, all will become apparent about this snail. It probably forms the basis of one of the most famous cases in English law. But more of that later. I just want to start by quickly going back over our tortious liability equation. It's what I want you to have in your head always when you consider problems. And you'll recall that there are 3 stages that we need to go through if we're a claimant. We need to be able to demonstrate as the claimant that we were owed a duty of care by the defendant. We then need to go on to show that that duty of care was breached or broken. And then finally we need to go on to show that the breach was not too remote, well, it was caused by the defendant, and that it wasn't too remote from the original loss, and that's known as damage. If we can demonstrate that we have a duty of care, or that there is a duty of care that exists, if we can demonstrate that there is a breach of that duty, and we can demonstrate that the defendant caused it and that it wasn't too remote, then we have tortious liability. If we have tortious liability, we demonstrate the wrong, and if we demonstrate the wrong, we are allowed to sue for remedy, which will normally be damages. Okay, so let's just start by looking at a little bit of background again. We've already told you that negligence is a tort. We covered that in our last video. And by that we mean it is a civil wrong. And that civil wrong, in order to demonstrate that we have a civil wrong, we need to show our duty of care, our breach of duty, and our damage. If we can demonstrate that we have a civil wrong by showing these 3 things, then we can prove that there is a tortious liability. I have been wronged, I have been negligently wronged, and I can look for remedy from the defendant. And the timepiece is here to demonstrate that this has been growing, this concept and idea of negligence has been growing over many, many years. What we're going to do in this video is we're going to look at just how do we prove a duty of care. Now, I cannot promise that this video is going to be quick. There is a lot to cover, and I do want to do it in one clear, one hit. I know a lot of you have preferred when I've done videos, even though they're slightly longer, in one complete hit rather than breaking them up. So I'm going to try to do that in this, and I'm going to try to keep the length as short as I can, but it will be slightly longer than normal. So, as with all of these things, we need some definitions. And if this is about, we go back to my original opening, if this is about liability and negligence, the first thing that we need to think about is what do we mean by negligence? And for most issues in tort, we will find our definitions, our legal rules, deeply bound in case law. And negligence is no exception. The definition of negligence comes from a clearly stated one from the famous case of Blythe versus Birmingham Waterworks Company in 1856. Again, you can see what I mean when I say it's been developing for a long time. And although the facts of the case of Blythe are not necessarily important, I will very, very briefly run over them. In Blythe, a wooden plug in a water main becomes loose in a severe frost, and the plug led to a pipe which in turn led up to the street. The problem was the pipe was blocked with ice, and the water, rather than going up to the street, floods a claimant's house. The claimant obviously being Blythe. And Blythe sues Birmingham Waterworks for negligence. And in that case, the judge, who's Baron Alderson, gives this very famous definition of negligence. And if you can, I would suggest that you try to commit this to memory. And he says that negligence is the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. Now, that's an 1856 way of saying doing something you should not, or not doing something you should. This latter one, of course, we already know as our omission, don't we? Okay. So, if you can't remember that, then just remember that negligence means doing something that you should not do, or not doing something that you should do. That's in short. And what Alderson does is place this person here, a reasonable man, right at the heart of negligence. And we're going to be talking about a reasonable man throughout the course of all of our videos on tort, because almost negligence pretty much focuses on the reasonable man throughout. And therefore understanding what that is very important. But for now, just park it. We'll come back to the reasonable man later. But we've got to ask ourselves, what is it that we should do? What is the thing that we should be doing? And that is defined as a duty of care. So we need to think about now, this thing that we should be doing, what does it mean? What is a duty of care? In short, a duty of care is a duty which one person owes to another to take proper care of the other. That's relatively straightforward. But the legal definition is more complex. So the legal definition is more complex. And the legal definition concerns the relationship, so it's based on a relationship between, I don't know what that was, between the defendant and the claimant. And the relationship is such that it must be that there is an obligation. So I've got that word there, an obligation upon the defendant to take proper care to avoid causing injury to the claimant in all circumstances of the case. So I've got a silly picture here, and a silly cartoon. But here, quite obviously, a father has a legal obligation to the wife of his children and to the children themselves. If I am driving my car, I have a legal obligation to make sure I drive it in such a way that I do not hurt other road users. We can think of many cases in which I owe a duty of care to take care of people, just in the way that I walk and so on and so forth. But the legal definition concentrates on this idea about an obligation. Now, before 1932, the law concerning what we actually mean by duty of care, this legal definition, is a little bit patchy. But in 1932, as you can guess from the sign, we are introduced to something called the Neighbour Principle. And the Neighbour Principle comes from probably, well, there's our snail again, but probably one of the most important cases in British legal history, Donaghy versus Stevenson. And the Neighbour Principle is formulated by a judge called Lord Atkin. And the facts of the case, I mean, we could literally spend a whole video just looking at Donaghy versus Stevenson. But what I will do is I'll give you a very brief overview of the facts of the case. We'll look at it again, perhaps in one or two other videos at different levels. And you may want to spend some time really digging deep into Donaghy versus Stevenson. It's one of those landmark cases that changes the shape of English law. And in Donaghy versus Stevenson, Mrs. Donaghy and a friend visit a cafe. It's in Glasgow. Mrs. Donaghy's friend buys her a bottle of beer. It's a bottle of ginger beer, actually. And the bottle is made of opaque glass, glass that you can't see through. Mrs. Donaghy has a drink, and then she refills her glass. And as she refills her glass, the remains of a decomposed snail pops into her glass. Now she's already drunk some of this liquid, and now all she's doing is now seeing, as she tops up, that the liquid that she's been drinking has been contaminated by a snail that has somehow found its way into the bottle at the factory. Mrs. Donaghy develops gastroenteritis, quite a severe stomach bug, as a result of drinking this contaminated ginger beer. The problem is that in 1932, Mrs. Donaghy had not bought the bottle of ginger beer. Her friend had bought it for her. And because she had not bought the bottle of beer, she could not make a claim against the manufacturers in contract law under a breach of warranty, because this legal concept of duty of care didn't exist. The House of Lords had to decide whether or not a duty of care existed as a matter of law, whether or not we have a legal obligation to take care of people around us, rather than a more direct contractual obligation that you enter into, for instance, when you would have bought the beer in this case. And the Lords held that the manufacturer did owe a duty of care, and that duty of care was to make sure that the bottle did not contain foreign bodies which could cause her personal harm. In summing up the case, Lord Atkin comes up with this very, very famous statement. And it's a development of the negligence issue in Blythe. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Now, I'll just stop there for a minute. Because what we should be doing now as lawyers is every time we read something like this, we know what an act is, we know what an omission is, we know what reasonable foreseeability is. But this is a new term. What do we mean by neighbour? Does it mean the person who actually lives next door to me? Does it mean the people who live in my village? Does it mean the people who live in a 5-mile radius, a 10-mile radius? Does it mean everybody in Great Britain is my neighbour? And that's what Atkin does. He goes on to say, who then in law is my neighbour? And he defines that by continuing, the answer seems to be the persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. Now there's one thing you've got to say for judges. They're brilliant at using 45 words when 2 would do. But in short, what we mean and what we mean by, or what Atkin means by this, is that if we take that as an example, if I'm out driving my car on the roads in, let's say, London, the things that I do in that car, or the things I don't do in that car, stop at red lights and so on and so forth, I need to consider in relation to the people that are on the road in London, close to me, around me. There will be people on the road all over the country. They are not going to be my neighbours. My neighbours will be those people who are on the road around me at the time, because they will be closely and directly affected by my act. If you think about Donaghy versus Stevenson, a manufacturer of a ginger beer bottle who then ships their bottles all over the United Kingdom for consumption, it's fair to say that anybody that drinks that ginger beer would be closely and directly affected by my act. So it doesn't necessarily mean, the Neighbour Principle doesn't necessarily mean that you've got to be close to you. It's a concept, it's a much larger concept, and it's about whether or not they are closely and directly affected by my act. Now, this is based on the biblical command about loving my neighbour. And it means that for the first time in 1932, there is a liability created without a contract. And this means that the law of negligence can develop. We can have a situation in which people can seek remedy for being wronged without having a previous contract with the defendant. Now, that's all well and good. A number of cases come out, but as society and culture develops, we find ourselves perhaps with the old Neighbour Principle not covering every single situation that we need it to cover. And in 1990 along comes our second major defining case. And the case itself is Caparo Industries plc versus Dickman in 1990. And Caparo Industries were a manufacturing firm really, but they specialised in things like high top of the end sports cars. Once again, you don't need to know the facts of the case. We will revisit them when we look at economic loss at A2. But in short, the case considers the liability of an auditor for financial losses suffered by investors. But what it does do for us is it sets out very clearly the 3 points which a court must consider to establish whether a duty of care exists. And those 3 points are these. To demonstrate a duty of care, so duty of care equals, you've got to show, is there a reasonable foresight of harm? Is there sufficient proximity of relationship? And is it fair, just and reasonable to impose a duty? I'm going to talk through each of these in the remainder of this video, but when you answer a question, this is a 3-stage test in the first of our 3-stage tests. So you've got duty of care plus breach plus damage. Remember? This is a 3-stage test in the first of that 3-stage test. All right? Complex, I know. Once you've got this under your belt, this is like the foundation. This is a building block for all tort. Once you've got these simple 3-stage rules, everything else becomes easy. I very, very quickly just want to give you an overview of the difference between the two. In 1932, Donaghy versus Stevenson says you have to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. That's the first part of what Atkins says. That, in Caparo, has now been brought up to date to say that means a reasonable foresight of harm. They're the same thing, but the language has just been brought up to date. In Donaghy versus Stevenson, Atkins goes on to say, who then is my neighbour? Well, they're persons who are so closely and directly affected by my act, so on and so forth. Those people now become those people with sufficient proximity of relationship. And what we've added, this is new, Caparo adds, is it fair, just and reasonable to impose that duty? All right, reasonable foresight, sufficient proximity, fair, just and reasonable. So Caparo is different from Donaghy and Stevenson because it adds this idea of fair, just and reasonableness to impose a duty. And just so you get a very, very quick overview, you'll see this again when we look at breach. You need all 3 of these elements. Was there reasonable foresight? Yes. Was there sufficient proximity? Yes. Was it fair, just and reasonable? Yes. If you have each of those 3, you have a duty of care. If you do not have any single one of them, there can be no liability in negligence. So you need to show, when you are answering questions, all 3 levels for duty of care to exist. Okay? And if we want to shorten that even further, my students just talk about the 3-stage duty of care test, the Caparo test. So this is the Caparo test as being foreseeability, proximity and reasonableness. And what we're going to do is spend the last part of this just going over each of those 3 elements. What do we mean by each of those three elements? I've got to make my way all the way to the top here now. So, let's start with foreseeability. Remember, this is the Caparo test. And stage one of the Caparo test is, was there reasonable foreseeability? And foreseeability is an objective test. It means, what would the reasonable man foresee? Think about Donaghy. Okay, a reasonable drinks manufacturer would foresee that a consumer might be injured if there was a snail in their ginger beer. They don't have to foresee that it was likely that a snail would have got in, but they do need to foresee the injury. If there was a snail in, is it obvious that somebody will get injured? Well, of course it is. Think about the old strict liability case, Smedley versus Breed, if you want to. I don't know if you recall the Smedley v Breed case, which is the caterpillar in a tin of peas. Would a caterpillar in a tin of peas have the same effect as the snail in Donaghy and Stevenson? Of course it would. So a reasonable manufacturer of peas would be able to foresee that a caterpillar decomposing in a tin of peas would cause injury. Consider this case when we think about as a good example of duty of care. It's a later case, so it gives us, it's an up-to-date current case, Kent versus Griffiths, 2000. And in Kent versus Griffiths, the defendant is the London Ambulance Service, effectively. The complainant is an asthmatic, and the complainant suffers an asthma attack. The complainant's doctor telephones for an ambulance, and the ambulance takes 30 minutes to arrive. The complainant suffers a respiratory arrest. Now, there are some similarities between this case and some other cases involving the police or the fire services that we'll talk about in the next video or two. And in those cases, it's often been held as a matter of public policy that there is no common law duty to an individual member of the public. And when we look at Hill versus the Chief Constable of Yorkshire, we'll look at a case in which it's very clear that as a matter of public policy, there's no common law duty to an individual member of the public. But in this case, the court decides that as there was only one person involved, and that person would foreseeably suffer further injuries by a delay, we could therefore establish proximity. We could foresee the injury. It is foreseeable that an injured person waiting for an ambulance may have more severe injuries if there is a delay. So when you are trying to prove foreseeability as the first stage of the Caparo test, you can use Donaghy, you can use Smedley, but I would use Kent versus Griffiths to demonstrate precisely what we mean by foreseeability. The second stage of our test is proximity. And proximity is related to foreseeability. I've just said to you in that previous case is that it would be foreseeable, and it would be, I said that the court decided that there was only one person who would foreseeably suffer. It was important in establishing necessary proximity. So proximity is related to foreseeability, and it means closeness. This is the old neighbour principle, isn't it? Who then is my neighbour? And what it means by closeness is that you can be close in either time or space or relationship. Now, we don't normally deal with time and space because they are relatively straightforward. If I have an accident in my car, I am going to be proximate in both time and space with the other person in the car, in the other car. And most instances, we are going to be able to demonstrate quite clearly time and space. And because of that, time and space are rarely an issue. And this is time or space or relationship. We only have to demonstrate proximity in one of those areas. Relationships are only relevant when the loss is foreseeable to a person in the defendant's position. And we're going to start off by looking at a couple of cases to look at this issue of relationship. Because time and space are rarely a big deal, we need to focus our case law on what do we mean by relationship. And the first of those is Boar Hill versus Young. And in Boar Hill versus Young, the defendant was a motorcyclist who was fatally injured. The claimant is a pregnant fishwife. She is getting off a tram when she hears the motorcycle go past, and somewhere in the distance she hears a collision. She didn't see the accident with her own eyes, but what she thought she'd do, bit of a nosy old beak, she thought she'd go and have a quick look for herself. Well, she got more than she expected, because when she arrived, she saw the blood and the gore and the aftermath of the accident, which caused her to have shock and subsequently miscarry. The legal principle here is that the claimant was not owed a duty of care as she was in a safe place and had not seen the accident. So there was no proximity in space or time. And it was not reasonably foreseeable that the accident would cause her to suffer such injuries. You cannot reasonably foresee that if I have an accident, some random member of the public, who I don't even know, who isn't even present, who just happens to be 500-600 yards away, who considers that they're going to have a sneaky look at what's going on, you can't reasonably foresee that they will be injured. So in this case, the claimant lost. Now compare that with the next one, which is McLaughlin versus O'Brien, and you'll see something slightly different. The defendant in this case was a driver who caused an accident which injured the claimant's family. The claimant visited the hospital and saw her injured husband and daughters, one of whom had died. What she saw and what she heard from witnesses caused severe nervous shock. And although distance, time and space are factors, they are not legal restrictions here. She certainly wasn't in the same space and she certainly wasn't in the same time as when the accident happens. But although she was not present at the accident, it was reasonably foreseeable, or it was a reasonably foreseeable consequence of the defendant's negligence. The proximity of the relationship was the deciding factor in establishing the duty of care in this case. So the claimant won. If I have an accident because of my poor driving, it is reasonably foreseeable that the family of the person that I injure is going to get upset. They are going to suffer some loss. That's different from some random who I do not know. That's the difference between Boar Hill and Young and McLaughlin and O'Brien. It demonstrates what we mean by relationship and when relationship can highlight a proximity issue. In most cases, proximity will not be an issue, and that's because the accident victim is part of the event. All right? But where a person learns about an accident later or sees it from a safe distance, and where the injury especially is psychiatric, then relationship is going to be a key factor. In terms of answering questions, it's probably fair to say that 9 times out of 10 you will be able to skip very, very quickly over the proximity element of duty of care. The third test then is reasonableness. And in this you have to say, is it fair, just and reasonable to impose a duty upon the defendant? And this has been born out of public policy. Courts have decided that in order to try and stop the floodgates issue, and for those of you that don't know what floodgates is, I'll explain. A floodgate issue is where if we start one thing and we say yes to one thing, then thousands, hundreds of thousands, millions of people might also want to have the same thing. So the system couldn't cope with some of those things. So in order to prevent the floodgates opening, in order to prevent a floodgate issue, there is a fair, just and reasonable imposition placed here. We've seen this concept of floodgates with ambulance chasers. You know, everywhere now is, have you been injured at work? Please dial 7717 and injury lawyers for you will help you out. You know, it's that idea, the ambulance chasers. And certainly in the States, there were cases where lawyers would literally chase ambulances to hand out their card to the person as they were taken into the hospital. That's where the term comes from. And this element, this reasonableness element, is designed to try and stop that. And because of that, members of the public sector are less likely to have a liability imposed on them. Now, earlier on, I said to you that when we looked at Kent versus Griffiths, that we were going to talk about some cases in which, you know, there wasn't a duty imposed. And here's the first one: Hill versus the Chief Constable of West Yorkshire. The police need to be able to act without worry about legal action in negligence. And this is a good example of that case. Hill versus the Chief Constable of West Yorkshire comes about as a result of the Yorkshire Ripper case. For those of you that don't know, that's Peter Sutcliffe, the infamous Yorkshire Ripper, a legal case from my youth when I was studying. In that case, the defendant, who were the police, failed to catch the Yorkshire Ripper. They actually, if I remember right, they had him, or they certainly came very close, and they failed to act on some information that they'd had. The claimant was the mother of the 13th victim, and she sued the police for negligence, alleging inefficiency and errors in their handling of the investigation. Her claim was, had you have done your investigation properly, my daughter would not have been killed because Peter Sutcliffe would have been arrested earlier. The court said clearly that the police owed no duty of care towards the daughter to protect her from the Ripper. Some further ingredient is invariably needed to establish the Some further ingredient is invariably needed to establish the requisite proximity of relationship between the complainant and the defendant. She, the daughter, had been at no greater risk than most other members of the public had. This meant that it was not possible to foresee the actual injury to this particular claimant. Now, go back here to Kent versus Griffiths. It is possible to foresee the actual injury to the claimant here. She's an asthmatic. They are on their way to treat the asthmatic. So their duty of care is to an individual. In Hill versus Chief Constable, the duty of care is to the entire community. And you can't reasonably foresee the damage to one individual and specific person. So this is a clear example of the Caparo reasonable test. But that doesn't mean to say that the police have an automatic get out of jail free card, if you excuse the pun. There are cases in which duty of care can be imposed on the police force, and we can look at these two cases to have a look at this. The first is Reeves versus the Metropolitan Police Commissioner. And in Reeves, the defendant, again the police, arrested a prisoner who was a known suicide risk. And he committed suicide whilst he was in their custody. The officers left open the hatch of the cell door, and he took the opportunity to tie his shirt to it and strangled himself. And the judge held that the duty of care had been breached. All right. Now there are some other factors in here, in the fact that the suicide was a novus actus, but he assessed contributory negligence of 100%. But the claimant wins here because the police knew that the defendant was a known suicide risk. They had a duty of care to make sure that he did not hang himself in prison. If we compare Reeves with Orange, the defendants were again the police force, and the claimant was again in police custody. Well, she's the husband actually. She's the wife of the husband who was in police custody. and the husband commits suicide, again by hanging himself with his belt from the gate of the cell. And the court says that although the police were under duty to take reasonable steps to identify whether or not a prisoner presented a suicide risk, the obligation to take reasonable care to prevent a prisoner taking his own life only arose where the police knew or ought to have known that the individual presented a suicide risk, such as in Reeves. So because they did not know in orange, so here the claimant won, here the claimant lost. And that's because they knew he was a suicide risk there, and they did not know he was a suicide risk there. So they could not reasonably foresee that that prisoner in orange was likely to take his own life, but they could reasonably foresee that that was the case in Reeves. And because they could reasonably foresee it, it was fair, just and reasonable. Look at that, I've spelled that wrong. It was fair, just and reasonable to impose the duty. Now, reasonableness has not extended to escaping prisoners. All right, a prisoner should not benefit from committing a crime. So in the case of Velino versus the Chief Constable of Greater Manchester Police, the claimant lost because it is not fair, just and reasonable to extend a duty of care to prisoners who choose to escape. All right, they should not benefit in their crime. However, it has been extended to solicitors. And this is one of several co-joined cases on similar issues where the claimants had done less well in court than they would, but for the negligence of their legal advisors. In effect, their legal advisors did not do what they should have done. And the courts held that it was no longer in the public interest that advocates, lawyers, should enjoy immunity from being sued for negligent acts concerned with the conduct of litigation, whether that's civil or criminal, although the fire service still retains some limited protection. And what that does is the claimants won, but it also changes the rules on lawyers' immunity. Okay, so I accept this video has taken a fair while, but the key thing, the Caparo test, in order to establish a duty of care, under the Caparo test, you need to be able to show, was the damage foreseeable? Was there proximity in time, space or relationship? And is it fair, just and reasonable to impose a duty? If you can demonstrate all of those three things, using them with the help of the cases that we've discussed, then you can demonstrate that there is a clear duty of care. And that will be the first element of your tortious liability equation proven.